The Vodacom versus Nkosana Makate matter returned to the Constitutional Court as the telecommunications company pushes for an order that will see its former employee bound by the 47 million rand offer for his Please Call Me invention. It's a landmark case that has gone through various courts, including the Constitutional Court, the High Court, the Supreme Court of Appeal, and back again at the Apex Court. Vodacom says the SCA erred in its majority ruling, which set aside a 47 million rand offer that Vodacom CEO Shamil Jasoob made to Makate in 2019.
Paragraph 34, the court said, I could find no objection by Vodacom to the models presented by Mr. Makate. That's the models for the determination of his compensation. Well, that again is an inexplicable statement, because the entire debate before the SCA was the debate on the CEO's determination of compensation on the one hand, and Mr. Makate's competing models on the other. We defended the CEO and attacked Mr. Makate. He defended his own and attacked the CEO. But the suggestion that there was no objection to Mr. Makate's models is again inexplicable.
The matter ended up at the SCA following an order by the Gauteng High Court, which set aside a 47 million rand offer that Vodacom CEO Shamil Jasoob made to Makate in 2019. His lawyers say the company has benefited immensely from Makate's invention and can afford a reasonable compensation in line with the High Court and the SCA rulings.
The point we want to make is the narrow one, that it's very difficult to say that the court disregarded all of the evidence. It clearly had regard to some evidence. So this is not a case like Rand Refinery, where there was a clear indication in the judgment that the judge seemed to find that the matter was unopposed. It's not a case like that. So in other words, if you can't isolate precisely what the court didn't have regard to that would have changed the order, then with respect, it shouldn't be the case that Vodacom can launch the kind of attack that it seeks to.
According to Vodacom, the SCA majority judgment undermined the rule of law under Section 1C of the Constitution and Vodacom's right to a fair hearing under Section 34 of the Constitution. But Makate's lawyers say the SCA was well within its right on the price determination review, as the CEO's determination failed to pass the Becker test. The Becker test is a legal argument that states that a court can only interfere with a CEO's decision if the outcome is patently inequitable. Makate's lawyers say Vodacom has not been honest with its finances and revenue collection from the invention.
For the CEO to tell us how outrageous and absurd our model is, it is of fundamental importance that he uses the correct revenue, obviously. One reads that, the paragraph just above the table, he tells you that revenue includes interconnect. But he doesn't use it to criticize our model.
The issue of jurisdiction also featured large during the proceedings on whether the Constitutional Court has the power to make a new price determination of what Makate should be paid or refer the matter back to the SCA for a review.
It is incidental to and follows from the constitutional complaint that we have, that we've never had a hearing. So we would imagine that this court may respond to it in two possible ways. This court can either give us the hearing which we have sought and to which we are entitled, and that would be our preferred option, just because we and Mr. Makate are both tired of litigation. But if this court is not inclined to determine the merits of the appeal, well, then the other way of doing it would be to refer it back to the SCA for a different panel to determine the merits.
Chief Justice Mandisa Maya reserved judgment in the matter. Katlego Logodi, SABC News at the Constitutional Court in Johannesburg.